We continue to see the California state attorneys get smacked down in these lawsuits, all in the name of Bruen. This time it comes in the form of Nguyen v. Bonta. This is a challenge to California's limitations on purchasing one firearm per month. Let's talk about it. Hey everybody, welcome back to the channel today. It's just going to be you and me again because we had an opinion drop that is just too good to pass up on. It may not be a CRPA lawsuit, but it is a big win for the firearms community in California. And some of the language that we see in this opinion, like I said, is just too good to pass up on. Again, we are talking about the Nguyen v. Bonta lawsuit. This is a lawsuit that challenges California's laws on limiting Californians one purchase per firearm per month. As usual, all in the name of safety. But before we get into that today, guys, please, it is helping. Be sure to like, share, and subscribe to these videos. It really helps get the information out to as many people as possible. As always, we are trying to arm everybody with as much information as they need to go to the ballot box in November and make the right decisions for pro-Second Amendment legislators. So coming into this, as is done, you know, in recent past, at least before Bruen, it was being done regularly. It's still trying to be done now. Before we actually get into the main arguments of the case, we're going to try to argue what scope it's going to be under, and that ended up being a rather contentious thing seemingly in this lawsuit, but in the opinion, the judge makes it clear Bruen is the way to go. Jacob, if you could bring this up on the screen, he summarizes this way. If there were somehow a categorical exception for all the regulations that could be characterized as conditions and qualifications on the commercial sale of firearms, it would follow that there would be no constitutional defect in prohibiting the commercial sale of firearms entirely, which is an untenable result. However, the precise contours of the commercial sales category are not defined in Heller, and the Court of Appeals in the Ninth Circuit has not clarified the category's scope. One approach urged by the defendants, that being the state, is to treat the commercial regulation as presumptively lawful if it does not act as a functional prohibition on buyers. In determining whether a commercial regulation amounts to the functional ban, Hirschfield instructs the courts to consider the severity of the restriction and whether it substantially burdens the group's rights. However, approach is inconsistent with Bruen, which repudiates any consideration of how close the law comes to the core of the Second Amendment right and the severity of the law's burdens on that right. Bruen suggests that the proper question in evaluating whether a regulation falls within commercial sales category is not the extent in interference with the Second Amendment right, but instead whether the regulation historically would have been tolerated. So here you have the state who's coming forth saying, you know, how is this actually impacting? We're not taking the right to purchase firearms away from the individual. So what is the interest balancing here? And here is the judge kind of slapping them in the backside of the head and said, guys, we're not going with the way that you twisted the Heller decision anymore. We have the Bruen decision. The Bruen decision tells us that we need to look at the historical analogs. So it's really good to see a federal district court judge do this. But then what do we come to? What are the analogs? So the first historical analog that the state decided to choose was some gunpowder regulations. Now, these regulations were really for, at least in the context of the time period, a safety measure to not put too much gunpowder in one storage facility so that if it did go up in smoke, it wouldn't be that big of an explosion. But then the judge slaps them and says this, defendant's analogy fails. The purpose of the OGM meaning one gun per month law, the why is to stop one gun purchaser from buying several firearms and transferring a firearm to another person who does not have the legal ability to buy a gun him or herself. So this goes to one of the arguments the state was making is straw purchases. And the judge is kind of saying here, look, you're not actually creating an analogy between these logs or these analogs and the law that's in question here. There's no similarity between this. What you're actually stating is we're trying to prevent straw purchases with this 1 gun per month rule, and I'm not buying it. So then what do they go to next? They're going to go to restrictions on sales to Native Americans that were from the founding period, which really end up being restrictions on a very classified group of people. And the judge slaps them again. He says this: as an initial matter, it is unclear whether it's permissible to rely on laws that, due to race or ethnicity-based classifications, would be unconstitutional today. Further, laws that disarm slaves, Native Americans, and disloyal people may well have been targeted at groups excluded from the political community, written out of the people altogether, and therefore their utility as historical analog is dubious at best. So here's the judge basically saying, look, I'm not going to let you bring the context of these old racist laws of people that wouldn't necessarily be considered in the same way today into this case as a credible analog. So he swipes that away. Then he goes further and says this: but even if the court were to consider such firearms restrictions as dangerous people, they do not impose a comparable burden to the OGM law. The identified historical laws targeted only a narrow subset of the population perceived as dangerous, while the OGM law, with limited exceptions, affects all people acquiring firearms. Further laws restricting the sale of arms to Native Americans impose neither a quantity nor time limitation similar to the OGM law. So again, here, you're not creating a proper analog that clearly defines a definition for, or a defense for, the law that you're defending right here. Not to mention the fact that these laws you're bringing are for a very specific group of people, where the 1 gun per month law pertains to everybody in California. So where are they going to go from there? They're going to go to dangerous weapons. And not only do they miscategorize some of these laws, most of these laws weren't even written for firearms, first of all. But second of all, they don't hone in on a very important aspect of the dangerous weapons laws and restrictions that we see today. And the judge writes this: further, the 19th century deadly weapons bans arose from the historical tradition of prohibiting and carrying of dangerous and unusual weapons. Both Bruen and Heller instruct that the Second Amendment does not extend such weapons, but rather only protects the weapons in common use at the time, such as handguns. So they kind of leave out the unusual part, and they completely gloss over the fact that the Second Amendment protects firearms that are in common use. So where are they going to go from here? They're going to go to taxing and licensing regulations, claiming they limited the availability and ownership of firearms. So the judge says this in response: the taxing and licensing regulations are not relevantly similar to the 1 gun a month law. Unlike the OGM law, taxing and licensing regulations place no limit on the quantity and frequency with which one could acquire firearms. In fact, the licensing regulations proffered by defendants impose no burden on the acquisition of firearms. They regulated only the seller. So it's like, try once, try again, try 5 times. It's not really working for the state in this lawsuit. The judge here certainly seems to understand the Bruen decision, looking through the lens of historical analogs. And the reason why I wanted to talk about this lawsuit in general is because this is kind of an overarching theme that we're seeing with the historical analogs that we're seeing in a lot of cases. So, try once, try again, but try with 5 different things here. It's just clearly not working. I think this is an excellent example of a judge who is understanding that we need to look at these cases through the lens of Bruen, not through an interest balancing test. And at the same time, it's an overarching theme that we're seeing not just with Nguyen v. Bonta, but with a lot of Second Amendment lawsuits in California, that the historical analogs, they just do not pass muster. The state is trying to bring all sorts of laws from the founding period of our country that really don't relate to the laws now, which is why we continue to see wins in the Second Amendment community with a lot of these lawsuits. So in conclusion, Jacob, if you can put this one up there too, just to round this out, defendants have not met their burden in producing a well-established and representative historical analog to the 1 gun a month law. The court therefore concludes that plaintiffs are entitled to summary judgment as to the constitutionality of the OGM law under the Second Amendment. It is hereby ordered the defendant's motion, that's the state, for summary judgment is denied, and the defendant's Daubert motion to preclude testimony of George Moskery is denied as moot. It is further ordered that plaintiff's motion for summary judgment is granted. No later than 7 days from the date of this order, the parties shall file a proposed judgment consistent with the order and include language that enforcement of the judgment is stayed for 30 days to facilitate an appeal. So one question that you might be asking as I've just finished reading this here is, there's no injunction written here. The injunction technically is written in the motion for summary judgment by the plaintiffs. So that's why this is being viewed as a win. Technically speaking, in that summary judgment, there will be an injunction on this law. But as you can see here, the judge has basically ordered that in that summary judgment, it needs to state that there is a 30-day stay on that injunction, offering the state a chance to appeal. It's going to be a pretty automatic assumption that the state will appeal it to the Ninth Circuit, but we are certainly going to continue and follow this case as it does. Again, this is a big win for the Second Amendment community. We're going to continue following cases like this that can be impactful up and down the state. As always, guys, please be sure to like, share, and subscribe. We're trying to bring you the most up-to-date information so that you can be armed at the ballot box come November. So thanks again, guys, and we'll see you on the next one.